Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a girl.
Hello, hello, hello. Welcome, everybody, to my winter living room. I love to keep the fire going. I love to look at my books on the shelves and work on my fancy computer over there on my big desk. We don't actually have a lot of time today, guys. We have to get going pretty quickly. So if you could go ahead, clock in for your shift, please. Hit that like button. We do have, it was live a couple minutes ago. It's probably still going, but we're going to watch some of Thurston County on a Monday. Oh, and it's a fucking Monday, isn't it? Has it been a Monday for everybody? Also, can we send good vibes to Mike? He's off having a job interview today. So let's send him some good vibes. Hi, Chuck, Bill, William, Vicky, Cellulite Yoga Pants, Shane. Sallyport was here. Sallyport's here. Who did I miss? Wahoo at the beginning. Okay. Okay, docker. Literally still live, ladies and gentlemen. But this case, I sort of scrubbed through. There's two lawyers, so I thought it might do well. Maybe it's catty, maybe it's not. I don't know, Blue Strat dude. It is not afternoon here yet. I refuse to acknowledge that. Anyways. Let's get her going. Judges just mentioned that many of his brothers are lawyers as well, but that this shouldn't be a problem.
Anybody has an objection to me hearing the case, then we can go from there. But and again, I guess it's time for you, Mr. Selby.
None from petitioner. Your Honor.
Okay, Mr. Ellington.
Your Honor, I have full confidence that if Your Honor thought you should recuse yourself, you would, so I'm okay going forward.
All right.
But let me confer with my client.
Sure.
Okay. Yeah, we agree.
Okay, so give me just a second to call up this case.
Okay, Judge, you take your time. Guys, high pass, drive safe. No, I don't think they've upgraded the cameras.
So before we get started also, give me just a minute.
Oh dear, her chin looks black. What is under her chin?
And this is directed to everybody on the calendar here today. So you're here either because you're asking for, or someone's asking for an order, anti-harassment order. And I just want to give a quick definition of unlawful harassment. And basically, unlawful harassment is a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, harasses, or is detrimental to such person, and that serves no legitimate or lawful purpose. Course of conduct must be such as would cause a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress to the petitioner. One other definition that's
Yes, we have an early show today, Miss Carrie. I have some shopping to do with my daughter and my Nana tonight. We're meeting at the mall and we're doing a bunch of different things because my Nana goes away, so she wants to like get my daughter her birthday present. It is October, her birthday's in December, regardless, whatever. So I'm here early. Also, I'm just gonna be frank with you guys. I might have stayed up all night watching a show by accident a little bit. My Fitbit says I fell asleep at 5 a.m. So if my eyes are puffy, that is why.
It's fairly important, is course of conduct, which is defined as follows. Course of conduct means a pattern of conduct composed of a series of acts over a period of time, however short, evidencing continuity of purpose. Course of conduct includes any form of communication, contact, or conduct, including the send, and then it gets into things about electronic communication, which doesn't necessarily apply to this case, but it will to others. And so those are the things that I'm going to be looking for and are important to determine whether or not an order, in some of these cases, temporaries have been granted, some of them not. And the issues today will be whether an order will be entered for the next year or whether the temporary will be extended for a year. And so both parties are represented by attorneys here. Attorneys, when they do different things, there's been a number of things filed, all of which I've read. We can, if you want, if either side wishes to put testimony on the record, you can do all that and then allow the other side to cross-examine, of course, or we can just argue, you can just argue off of what's been filed and then make a decision going forward. So Mr. Selby, and I can either swear in your client, which either or both of your clients and proceed, or we can proceed on, and then I'll hear from Mr. Ellington as to what his position on that is also.
Thank you, Your Honor. Good
Sure.
morning. For the record, Clay Selby. I'm here with Jay and Lorraine Manning. Your Honor, I believe that Mr. Manning and Ms. Manning are not planning to testify this morning. We're going to rely on our pleadings. I do have some argument as to that
Sure.
effect, but I believe the record's pretty complete as to the bases for the order.
Mr. Ellington?
Given their representations, we'll do the same.
Okay. So as a petitioner, Mr. Selby, I'll hear from you first.
Sure, Your Honor. Thank you. Your Honor, I appreciate you having taken the time to review the pleadings. There's actually quite a bit here for an anti-harassment matter. And one thing I would ask is the court to consider both the course of conduct prong, but also the single act of violence as a potential means, an avenue here for issuance of the anti-harassment order. I think they both fit given our facts. Basically, the Mannings need the harassment and the intimidation to end. It's been going on for years. If you go back to the petition and to Jay Manning's declaration and Lorraine Manning's declaration, there's evidence before the court that shows a pattern of harassment that goes back years by Mr. Dunn to the Mannings, things involving the easement on the shared roadway access to the Mannings home.
It's always an easement. It's always a fucking easement. They should call them something different because there ain't nothing easy about it. Seriously, it is seriously a fucking easement. Also, Mama Llama, welcome back. We know the Boone trial has been a boon. No, not a boon. What's the opposite? An anchor? No. I don't know. I'm not sure. A lead ball, a lead weight these past weeks. Come on, give us some dirty details, dude. A bust. There we go. Not skibbity. That's right. Fuck. Not skibbity. Let's let this cook, shall we?
Where Mr. Dunn has repeatedly over the years obstructed access to that easement. This goes back numerous years. And you've seen, Your Honor, that not only has there been a prior lawsuit back in the early 2000s involving Mr. Dunn, that's at Exhibit A to Jay Manning's declaration. That's the Roberts v. Dunn case. Now, admittedly, my clients were not party to that suit, but the facts in that are so alarmingly similar in terms of the harassing behavior by Mr. Dunn to a neighbor that we thought it was important that the courts should see that. Since that time, Mr. Dunn has done similar things to the Mannings over a course of years. You see that in 2021, the Mannings, along with other neighbors, had to file suit in Thurston County Superior Court. A preliminary injunction was entered against Mr. Dunn due to his manipulation of water access for the neighbors, including the Mannings. And the various harassing behavior that he had imposed upon them, including the Mannings. You see that Mr. Manning's declaration from that 2021 lawsuit is included as Exhibit B to his declaration here. I raise this because it obviously gives additional evidence to a course of conduct that goes back some years. Previous courts have considered Mr. Dunn's behavior, and in at least one instance, a preliminary injunction was ordered. More recently, we have obviously the July 27th wedding incident. This is what really prompted the Mannings to come forward and seek this.
July 27th wedding incident. Look at me going old school because I happen to have a calendar here. So July 27th was a Saturday. Ugh. Also, I think it was a half moon. The waning half moon on the Saturday that we got married, and the Mannings came over and the Dunns came over and they ruined the wedding. Why would your neighbors have anything to do with your wedding? Why would you get married at your house if you have shitty neighbors? Mike is driving back from Orlando, putting on my glasses, wish they were real. Actually, I don't. I have better than perfect eyesight, but sorry. It's the last quarter of the moon. The last quarter of the moon that was on the wedding. Anywho, hi Casey Carey. Mike, we're so happy. We've been thinking about you. I've been sending vibes. I hope it went well. I mean, this is why I went to a different country to get married. Awesome. That's perfect. No offer on the table yet. Well, why would there can't, that's normal. You wouldn't be getting an offer right yet. Don't worry. I have good feelings about it. Anyways, let's just finish hearing about the July 27th wedding incident, and we'll go from there.
Disorder. They were hosting a wedding party. Mr. Dunn crashed the party, for lack of a better term, on his golf cart, trespassed across the Manning's property, ended up hitting 3 different people, including Jay Manning, with the golf cart. Your Honor, under the single act of violence prong of an anti-harassment order, that in and of itself should be sufficient to enter the anti-harassment order, because the golf cart could certainly be considered a weapon. Mr. Dunn was presumably intoxicated. You see from Mr. Manning's declaration that Mr. Dunn was slurring his words and appeared to be inebriated, but we don't have any evidence other than that. But obviously that incident, which is documented not only by my clients, but by the 3 other witnesses who have filed declarations with the court, including the bride at that wedding, caused extreme fear to the Mannings, to their guests, and it was dangerous. It was very reckless. Lorraine Manning has testified in declaration that she previously has specifically told Mr. Dunn not to come onto their property, yet he continues to do so. He has also told her within the last several months prior to this temporary order being issued that his behavior, things such as stealing their sign repeatedly at the base of their driveway, placing things along the edge of the shared road access, that, nails and screws and cement blocks and garbage, that he's doing this specifically addressed to them and their other neighbors, the Adrians. This is clearly both a single act of violence and a course of conduct that is harassing, annoying, alarming to my clients. A reasonable person would be alarmed and feel harassed by this. And in fact, the Mannings do feel alarmed and harassed by this. So certainly we've met the burden to show unlawful harassment. Obviously the court has seen Mr. Dunn's declaration and the other declaration he filed in response. I don't see anywhere in there any evidence of it.
I'm changing the title. Golf cart wedding. Is attack too much? Is YouTube Daddy gonna get mad at me if I use attack? Golf cart wedding fiasco. There we go. Fiasco. Save. Right? I think fiasco's fine. I think attack they might be a little concerned about, but we'll go with fiasco.
We've got passion, we've got determination. Like, and if we
What?
set our sights on something,
got
you better
what?
believe it's happening.
Oh, an ad on my own video. That's quite hilarious. I apologize. One second. I had to get the chat back. That's funny. Okay. Muted. Let's go. Also, the Delphi trial I thought was going to be posted.
A legitimate or lawful purpose for any of these acts. There is none. He's offered none, and there is none. An anti-harassment order is appropriate and necessary. I would ask for the court to enter that along the exact same terms that were in the temporary order. And I will ask the court as well to, if the court is inclined, to require a mental health evaluation and follow-up treatment, as well as an alcohol and drug evaluation and follow-up treatment. And I can get into the specifics.
I will tell you that I'm
Yes.
not going to do those things. We don't have the mechanism to enforce that. And so I'm just going to let you know up front that
Thank you.
that's not going to be ordered. And
Because the court
we
doesn't have the mechanism.
We can't, I mean,
I understand.
yeah,
Your Honor.
we just don't do that.
I understand. I have nothing further unless Your Honor has questions.
Okay. I don't. Mr. Ellington, I might in a minute, but Mr.
course.
Ellington, I'll hear from you.
Thank you, Your Honor. Well, counsel and I agree that this is conduct that goes back actually more than 20 years. Goes back to the family. This property has been in the family for a long time. And it used to be quite a large parcel. Back in 23 years ago, I believe, is when the Mannings purchased one of the parcels from the family. And subsequently, there's been 4 or 5, 6 parcels sold off. There is a water system that is on Robert Dunn's property, but the Mannings are not part of that water system. So they have nothing to do with the water system. The course of conduct here, a lot of it is litigation that's gone on, going back to the 2007 era, went to the Court of Appeals. This is litigation. This is not a course of conduct that satisfies the anti-harassment purpose or anti-harassment statute.
Wasn't some of that 2021 stuff? I thought I saw a reference in there that RCW 1014, which used to be the anti-harassment statute, but it's now it's chapter 7. But it looked to me like the harassment was an element of that Superior Court litigation in 2021 too, I thought. Or
Well,
I may have the year wrong, but
the Mannings have raised this issue, and which segues into my next point is there. Another argument I have, though, is the Superior Court action. The Superior Court has this case. They're very familiar with this case, maybe more familiar than they want to be with this case, but they've gone back and forth. An injunction was imposed at one point. The proper venue for this case really is Superior Court, unless there's something new and compelling enough to cause a new cause of action in the district court. And so a lot of the old history in this case going back in time before the date of the wedding of July 27 of this year, really, I think, is the purview of the Superior Court. And so it's been litigated. Superior Court is aware of it. The Mannings are not a part of the water system. And so it really leaves us to the only incident in this case that's, as far as the debris and property on the roadway easements like that, the signage on the trees, Mr. Manning or Mr. Dunn has a right to do with his property what he wants to do, so long as he's not violating code enforcement laws or hazardous materials laws or storage laws. So if he wants to have an old boat on his trail on his property, he can do that. If he wants to have a honey bucket on his property, as long as it's not a public nuisance, he can do that.
what about the screws on the road?
Well, I've traveled a lot of roads, and Mr. Dunning didn't address it in his response because he doesn't know. Those screws, I don't know who has personal knowledge of how those screws got there. Mr. Dunn doesn't know. He didn't respond to it because he doesn't have any knowledge. Those screws could have fallen off a work truck going into one of the properties where Mannings or the neighbors live, Morrison's. Could have been a box of screws that fell off a truck. Could have been there for 20 years. We don't know. But there's no personal knowledge under evidence rule 602 or any other evidence rules to substantiate where those screws came from. I agree that nobody wants screws on the side of the road and nobody wants to have a flat tire. But I don't think you can just dump that on Mr. Dunn as the responsible party for that. And so, which brings us to the
And I
golf
guess
cart.
the question I have is, what about the, he referenced, and I saw this in the declaration also, the signs. Apparently there's an allegation that Mr. Dunn has been taking signs down that were put up by the Mannings, like I'm familiar with the area. I don't know that I've ever been out there, but you see all kinds of arrows, you know, the Smiths live here, the Jones live there. I assume it's that type of sign. Let's say.
I don't recall what sign they were referring to, what it said.
Okay. No, but apparently they have a sign on there. As I understood, as I recall the declaration, it was a sign that had some sentimental value to the Mannings. It was made by a relative or something. And then he had taken that down, and then there was some negotiations going to get the sign back up. And I don't know whether the sign's up or down now, but
the best part about my show is that nobody in my family seems to watch ever. So I was just thinking, how fucking petty of these people. And I glanced over at my own little petty thing that I'll explain in a members only. I can't risk it live, but we'll talk about it in a members only soon. But let's just say it's within feet of me, my precious.
what's that all about?
Okay. That sign was returned to the Mannings, and Mr. Dunn simply didn't want that sign on his property, but the sign was returned to the Mannings.
Okay, go ahead. You can continue.
So, Your Honor, it leaves us to the isolated incident here is the July wedding incident where Mr. Dunn came home with a friend, Mags, who we filed a declaration of Mags as well. They heard music playing down the beach a ways. This is a neighborhood where people have known each other for years. Mags and Mr. Dunn got in their golf cart and they went down to the beach thinking that they would go down and enjoy some music and maybe some dancing. They had what they perceived was an open invitation to any of the neighborhood functions. They've been doing that for years and years and years, and they'd always been welcomed by the neighbors in the neighborhood.
You're gonna have to fucking bring this one around, bro, because it's one thing to go to a wedding, like go to an event and then be asked to leave, but he supposedly ran over 3 people with a golf cart. Tom Petty, right? No, but seriously, like, how are you gonna bring this one back, lawyer dude? Because first of all, a wedding is not a regular family function. If you know the wedding's happening and it's a wedding thing, you have to be invited. You can't just do that. That's not appropriate. I'm sorry. I'm Canadian. Now listen, I imagine that most people would invite their neighbors if they didn't have 20 years of death litigation, it sounds like, between them. Why would you think you're invited to that? That doesn't make any sense. Come on now.
They went down there that night. The dance floor, as it's described, was really a gravel area in the middle of the bottom of the roadway. And so when you come down the steep hill and enter into the gravel area, it's not like you have the choice of going down the road. You are already in the center of the gravel area where the dancing was taking place. Mr. Dunn engaged with a small girl at the time, said hello, recognized him, cordial exchanges, and then he proceeded to enter the area. They realized the music was louder than what they wanted. They were going to leave, but there was no way to turn around because of the steepness of the driveway. They just come down, so they were inching their way across the dance floor in an attempt to turn around. And that's when suddenly Mr. Dunn was grabbed, yanked out of the golf cart, thrown to the ground twice, assaulted. In fact, filed a police report 2 days later with the sheriff's department to report that assault. But in any event, Mr. Dunn does not believe he hit anybody with his golf cart. And even if someone was touched with a golf cart, they use the word accelerating. And when you go from 0 to 1 mile an hour, by definition, yes, you are accelerating because you are increasing your speed. But at no point in time did Mr. Dunn drive the golf cart in any egregious way or reckless way in that situation. He simply showed up there, and the wedding itself, the venue, was not even on Manning's property. It was on Sid Morrison's property. And so, which is more compelling in the sense that it's not even the Manning's property he went to. And so once he realized he was going home, once he realized he'd been tossed out of the golf cart, he was bleeding. He was in pain, and at that point, he just simply wanted to go back home, and that's what he did. He went back home. And so it's an isolated incident. There's no intent on his part. His intent was to go there. His intent was to enjoy the music and maybe dance.
And crash a wedding? Dude, you're so old for that. That's inappropriate. It is not acceptable to ride a fucking golf cart into a wedding party. Into any sort of not your property. Like, oh, the hill was so steep we couldn't get around. Well, perhaps that's a good fucking indication you shouldn't have been there to begin with. Officer Porkchop, howdy. Also, he waited 2 days to report his assault? Did it take him 2 days to clamber back up the hill?
But once he got there, he realized he didn't want to stay because it was too loud for his ears. And he simply inched his way across in an attempt to find an area to turn around. And so I think the course of conduct here is not ongoing. The course of conduct goes back to Superior Court actions that were litigated. As far as an isolated incident, I don't think this rises to the isolated incident of an assault that would warrant the issuance of an anti-harassment order. And so what I'm asking the court to do is dismiss this action. I think both sides realize the seriousness of the process and the inconvenience to all parties concerned. But I would ask this court to dismiss this action. And if the court was inclined in any way to issue a temporary order, I would ask for alignment that would also keep the Mannings from crossing through Mr. Dunn's property when they don't need to.
So, bro, did you file a counter petition? I'm not a lawyer and I know how it works. Everybody that comes in here that didn't do anything and doesn't need an order against them was like, by the way, I also want an order too. I want them to not come near me. This is fucking petty. Okay? I'm going to tell you right now. I'm on the Manning side. Hi, Lisa. Hi, Donald. You know what I mean? Like, I'm feeling that he shouldn't have been there. He intruded. He fucked up. He was drinking, bringing his Mag's friend down there. Like, bro, this is like a movie. It's actually like a scene from a movie. Like, if you wrote this with a few celebrities in there, this is a scene from a movie.
They have a right to the easement of the road. I acknowledge that, but they don't have a right to go anywhere outside that easement. So, but I would ask the court to dismiss the action.
Okay. And then Mr. Selby, I'll give you the final word.
Thank you, Your Honor. Mr. Ellington is doing his best with the facts he's got. This is not a simple isolated incident that was a simple misunderstanding because Mr. Dunn thought he could attend the party, and that's what he does.
Nobody's removing comments, William. Talk to YouTube Daddy. There's not even any mods in here except for Cellulite Yoga Pants, possibly. She knows. She don't remove comments. And I'm not removing comments. It's YouTube. What are you trying to say? Spell it like phonetically or something. You know I don't fucking censor shit like that.
Evidence that's before the court shows that Jay Manning tried to get him to stop before he entered the dance floor on his golf cart, mind you. And there's dozens of people on the dance floor, and Mr. Dunn drove onto it through people and hit 3 people. Jay Manning tried to stop him. Jay and Lorraine were hosting this wedding party. Mr. Dunn had to trespass across their property on his golf cart to get there. So quite frankly, all you have to do is look at the 3 declarations from Alex Boyle, Alyssa McKendry, and Todd Onlid to show that this is not, Jay and Lorraine just blowing something out of proportion. These are people who attended the party, witnessed this, and have filed sworn testimony with the court. This was a violent dangerous action. Was it an assault? I don't know. We're not here in a criminal matter right now. Could it be a reckless endangerment assault? Absolutely. But that's not for this court.
I'm trying. I mean, honestly, William, if I fucking knew the words that YouTube Daddy allowed, don't you think I would share that with you guys? I would. Believe me. Believe me. I already don't believe that YouTube chats are reflective of the YouTuber. We've talked about this in the past. You guys go to chats where they're fucking strict as fuck. I don't believe that that's the same thing. However, my channel is the smallest and slowest growing of all of those, so perhaps I'm fucking wrong. You know? Maybe we're just choking our own chickens.
Violent act with a weapon, that being the golf cart. But more than that, there certainly is a course of conduct here, and it's not a Superior Court matter. That case is closed, Your Honor. That's why it's not before the Superior Court. But this court has jurisdiction over an anti-harassment order, obviously. And the course of conduct has been demonstrated here going back a number of years. You've pointed it out. The nails and screws, you can look at the photographs attached to Jay Manning's declaration from the 2021 cases. We're not talking about a couple. We're talking hundreds along the side of the road. Mr. Dunn did that to try to keep people from extending out onto the easement further. He wanted to keep people on this one-lane road. Unfortunately, it's literally a one-lane road. So if people are coming and going, you have to get off. You have to slide off to the side. And that's why the easement extends beyond it. He's trying to control it, just like he was trying to control the water system. This is what he's doing to the Dunns and the other neighbors. He told Lorraine, this is what he's doing to the Mannings. He told Lorraine Manning that he was doing this directed to the Mannings. That's clearly showing intent to harass. And I still haven't heard any evidence of a legitimate or lawful purpose. So I do think there's more than enough there, Your Honor. I would ask you to enter the order. I would ask you to enter it for 1 year. And I would ask the court to also issue the Mannings an award of their attorney fees and costs.
Okay. Just a second.
All right, get your... Oh, you can cross lines of decency here, William, but we just allow it. We just allow it, you know? Miss Carey's here too, I forgot. Here's the thing, get your votes in now. What do you think? Is he going to issue this order or not? YouTube won't allow it. I know. Believe me, YouTube Daddy and I are at odds some days. I'll tell you, you know who actually is more honest than YouTube Daddy? OnlyFans Daddy. Can you believe that? Shocking. Anyways, you think a big dismissal, the big D. You really think that, I actually think he's going to put this order in place. I do. We disagree. Paisley, you have to hit play. We got other shit to do today.
So again, I've reviewed the entire file, listened to argument of counsel, and with regard to the order, my ruling is as follows. First of all, I don't agree that this is an isolated incident just occurring in a vacuum where he just happened by to a party he had heard about, then for the purpose of showing up and, again, this declaration said having some cake and dancing. This is conflict among Mr. Dunn and Mr. Mann and the Mannings and several other neighbors going back, as everybody indicated, 20 years. And I kind of reached a boiling point with regard to the incident that occurred at the Mannings niece's wedding, where Mr. Dunn came onto it was referred to as a dance floor, but I did pick up from the declarations this was a gravel patch of some sort, where he just drove his golf cart through there. A couple of people were alleged to have been hit. I think Mr. Manning indicated that a foot was ran over. And, and I just have to, Mr. Dunn in his declaration says, no, I was just trying to get out of there, easing through. But, looking in the vacuum, looking not in a vacuum, but the declarations filed by others, I just driving a golf cart through through a group of people who are dancing to loud music makes no sense at all to me. And even if you're going just 1 mile an hour, and apparently there were kids walking around, and some people in their declaration indicated they were looking for their kids, to grab their kids, to get them out of the way. And so, yeah, it's not just an innocent thing that happened where someone showed up at a party and then decided to leave. I think that could have been handled a lot better. And this is combined with behavior that has gone on directed towards the Mannings as well as other neighbors out there going back 20 some years. But with regard to the Mannings, based on their declarations indicated, Mr. Ellington is correct that yes, you can do things to your own property, but I mean, who does that? Who takes a spray painting to a tree other than to, annoy other people? And so, and again, with regard to the screws, I'm not making a finding that Mr. Dunn did that, but the other things that he has done that's contained in the declarations, I do find rises to a pattern of conduct. And again, the most serious thing was the thing that happened most recently. And so I will find that a pattern of conduct had existed, and I'm going to enter an order that's going to exist for 1 year. The one thing I do want to talk about among council is that had a distance restriction on the temporary order. And I don't want to enter an order that prevents Mr. Dunn from making use of his entire property. And so if that 300-foot distance restriction affected where he could go on his own property, then we're going to need to talk about that. And so, and I do know that I did notice that I was the one who entered that temporary order. And so what I do a lot of times, and again, I'm when out there, I've not seen the geography out there, but just say that there's not to have any contact, don't communicate, no stalking, no causing of any harm. And then right in there, they're just not to come onto the premises of the Mannings. And then there's not a distance restriction. That way Mr. Dunn can have the use of his entire property and stay off the Manning's property. And again, you both have a right to the easement. You're both going to be able to use it, but leave it at that. So I guess I don't know who wants to comment first. Mr. Selby, I'll hear from you, and then I'll hear from Mr. Ellington.
Sure.
But I am going to enter an order. And again, I'll cut to the chase in later things. This time I'm not going to order attorney's fees for either party. And I told you before, I'm not going to do the mental health or understood. Right. But go ahead. I'll hear from you on.
Your Honor, we do ask the court to keep the 300-foot restriction from the residents. I recognize the court's position. We've considered that. A concern that we have is based on the history with Mr. Dunn is that if he is allowed closer than 300 feet to their residence, that he will resume harassing behavior. There will be more spray painted trees. There will be garbage that piling up on the edge of the property, so as they walk out of their house, there it is. 300 feet should be sufficient. I understand the court's position, but ultimately, I think that the statute allows the court sufficient discretion to provide a remedy that will ensure the protection of the petitioners. And that's what we're asking you to keep that 300 foot.
Mr. Ellington.
Your Honor, I agree with the court's analysis that the only logical and fair way to do this is a 0-foot distance requirement. That gives him the lawful use of his own property. I think the court to infringe upon the lawful use of his own property would raise a host of different legal issues. But if the court puts 0 distance and specifically says that Mr. Dunn is not to go on the property of the Mannings, it's clear that he can't step across the property line. And I think it's also clear that if the court puts in there, there's to be no further harassing conduct, that if he were to, example, put up 20 signs facing their house right outside their bedroom window, or start storing honey buckets right next to their back patio deck, things like that, that the Mannings would be right back here before Your Honor with additional ongoing harassing conduct, which would violate this court's order, and this court would deal with that appropriately. So I think under the circumstances, I think Your Honor's analysis is spot on to go with 0 distance, but no further harassing conduct of any type, no contact, etc.
Your Honor,
I'll give you the final word here there, Mr. Selby.
would you consider hearing briefly from Mr. Manning on the property distance issue, Your Honor?
If we do, that may
Then
open
I'm-
up Mr. Dunn.
Yeah, that's just what I was gonna say. I can swear him in and hear from him, and then if Mr. Dunn wishes to respond, he can do that.
Yes, Your
Okay.
Honor, if we may. Thank you.
And then you also might be subject, you will be subject to cross-examine. Mr. Ellington can ask you questions also. Could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth? You can put your hand down. Go ahead. What do you wish to
Well,
tell me?
Is that true? I thought he was using bees. I'm not joking. I thought he had like set up a bee area near the property line to agitate him with a big pot of honey. I did not think it was a shitter. What a weird life. What a weird life. Seriously. It's so childish. Hi, Lisa B. And guess what? Now we get to hear from both of them. Will the judge change his mind? I don't think so. Let's see.
As you leave our property and go up the hill, and then you eventually come out and hit Beachview Lane, the road that comes down that other neighbors use. As you come down Beachview Lane, you take a right into our driveway. The first 70 feet of that is on Rob's property. It's actually, I think it's owned by Rob and his brother. That's where the signs were that he took. And that's where he painted right on the property line, a big white swath with no trespass right across the middle of the road. He cleared that whole area up above the road of vegetation and sat up there with his buddy and had a campfire for a couple of days. It is a place where he knows he's gonna be able to, and he has harassed us. It's within 100 feet of our property. I measured that. So what I would ask is enter the order as you described, but don't allow him onto that spur off of Beachview Lane that comes into our property. It would only be about 70 feet of his property he couldn't access, but it's really important to us that he not be able to get into that area. Thank you.
Okay, Mr. Ellington, do you have any questions?
No questions.
And then Mr. Dunn,
I'll
Does he- would
respond
you wish to-
briefly and then I'll ask Mr. Dunn if he wants to add
Okay.
anything.
go ahead.
Your Honor, if an owner of property wants to go up on a piece of their own property and build a campfire and enjoy the view of the water, the question becomes does that conduct reasonably annoy a different neighbor, another neighbor? And if that is the context of what Mr. Manning's asking for, then Mr. Manning's perception of Mr. Dunn sitting around a campfire on his own property in an area that's cleared to obtain a view, that does not affect or annoy a reasonable person. And so Mr. Dunn should be able to do that. And we'll rest on that.
Okay.
If we go down this path, it opens up a nitpicky for nitpicky. And if we simply draw the line that says 0 crossing the line, 0 conduct that has harasses or annoys a reasonable person, then I think we've addressed the issue.
And so, again, I find that there has been a pattern of harassment. I am going to enter an order that's going to exist for 1 year. And whether that needs to be renewed or not, Mr. Manning can speak with his counsel about that. The parameters of the order are he's not to cause you any harm, no contact of any sort. No contact means no contact. That means no calling, no texting, no emailing, no yelling at them across your property, sending third-party contact. Hey, go talk to the Mannings about this or that. Any of those things would be considered a violation. Do you understand that, Mr. Dunn?
Yes, sir.
He's not to engage in stalking behavior, which includes following around, filming, or anything of that sort of behavior. And he's not to come on to, he's just not to come onto your premises. You know, I hear what you're requesting me to do about keeping him from accessing his certain portions of his property. But I'm just not going to do that at this time. He's just not to come onto your property, and I'm not going to put a restriction on what he can do on his own. But if his conduct on his own, you feel is a violation of this order somehow, you can address that.
Understood.
And if you wait a minute, if you can wait, I can give you a copy of the order here right now, but you can access it off the Thurston County District Court website later if you wish to.
We'll wait if we can, Your Honor. Thank you.
And actually, since you're all here, why don't you hand this down to you, Mr. Selby, first? And then you can take that and sign that, and then hand that over to Mr. Ellington, and then give it back up here.
Thank you.
So put in place, but no distance restriction. I think that's probably the right case here, or the right call here. No, he's giving them the order to sign in person instead of docu-signing.
There's someone on the Zoom call listed as an observer. Could you
me,
identify?
Judge, that's me, and we don't need to get into it, in fact. I'd rather not. We'll talk about that later. I sent an email. On that note, I hope that you guys have a wonderful rest of your day. I won't be back on tonight, but we'll be back tomorrow. Who's lurking? Me! I'm lurking in all the courts. We'll be back on tomorrow. We Gotta Chase is coming up at 405 East, which is 105 Pacific. And yeah. Let's have a good time, shall we? Can you guys do me a favor? Remember that I love you and I'm proud of you, and I will see you in the next video. Bye.
Ways down and ready to ride.